Like this, now be small matter. They happen for the social media since this gist fall out today. So wahala. Before, when Peter Obi start this petition, this tribunal matter, they thought say it's just wasting the time. And Peter Obi should go and sit down. He should just rest now. Nothing will come out of it. Now. But say fear don't they catch them now. So because according to the gist wey fall out for this day newspaper today, so they say Tinubu don't they talk say nullifying the February 25th presidential election on account of not scoring 25% in Abuja could lead to chaos and anarchy. Now the matter I for come out today. Back I be big. I just read the news come out when I hear the full gist. Because not be small wahala they have for the social media lifestyle. So this is for my follow-up. So just listen to the full news. It said Tinubu won that nullifying the February 25th election that produced him as president on account of the fact that he did not score 25% of the lawful votes cast during the election in the Federal Capital Territory could lead to absurdity, chaos, anarchy, and alteration of the very intent of the legislature. Besides, Tinubu told the Presidential Election Petition Court that the two petitions filed by candidates of the Labour Party, Mr. Peter Obi, and his counterpart of the People's Democratic Party, PDP, Alhaji Atiku Abubakar, seeking the nullification of his victory at the February 25 presidential election are not only novel but not familiar with the country's electoral laws. Tinubu's submissions were contained in his final written address against the two petitions pending at the tribunal. The 5-member panel had on July 5 given the respondents in the two separate petitions 10 days to file their written address, while the petitioners were given 7 days to reply. The panel, led by Justice Haruna Samani, gave the order shortly after Tinubu, Shetima, and the APC closed their defense in the two petitions, as it would be recalled that INEC had closed its case a day earlier. Both Atiku and Obi, alongside their respective parties, had dragged INEC before the tribunal for declaring Tinubu and the APC winner of the presidential election. Amongst the reliefs they seek is the nullification of Tinubu's election on the grounds that INEC did not substantially comply with the guidelines and regulations for the conduct of the 2023 general elections and relevant electoral laws. INEC's chairman, Professor Yakubu, had on March 1 returned Tinubu as the winner of the February 25 election with that number of votes, while Atiku and Peter Obi were said to have scored those number of votes respectively. Besides faulting the figures which they claimed were incorrect because the collation of results was still ongoing when Mahmoud returned Tinubu as the winner, the petitioners also claimed that Tinubu cannot be said to have won the election, having not scored 25% of the lawful votes cast in the FCT. Besides, the two petitioners argued that Tinubu ought not to be on the ballot because of an alleged United States District Court judgment that ordered his forfeiture of $460,000 suspected to be proceedings of drug trafficking. Another ground they are seeking is disqualification regards the alleged double domination of Shetima, who according to them was already a senatorial candidate for the APC in Borno Central Senatorial District election conducted the same day and time with the presidential poll. While Atiku, before closing his petition, called 27 witnesses including INEC's presiding officers and experts, Obi on the other hand called in 13 and tendered a plethora of documents including over 18,000 blurred results sheets on which INEC based its declaration of Tinubu as the winner. Although INEC, Tinubu and the APC had interrogated the validity of the witnesses and documents to the petition and asked that the court to discountenance them. However, Tinubu, Shetima and the APC in the individual written final address have asked the court to dismiss the two petitions because the grounds upon which they are built are not familiar with the country's electoral laws. The petition in issue in this address is very novel and in the sense that it is not a petition stricto sensu, familiar to our electoral jurisprudence, as the petitioners are not this time around complaining about election rigging, ballot box snatching, ballot box stuffing, violence, thuggery, vote buying, voters intimidation, disenfranchisement,
interference by the military or the police, and such other electoral vices. The crux of their grouse this time around is that while the presidential election was peacefully conducted all over the country, as corroborated by their primary witnesses, and the results accurately recorded in the various Form 88As, some unidentified results were not uploaded electronically to the INEC election results viewing IREF portal. The other remote contention of the petitioners is that the second respondent did not score 25% of the votes recorded in the FCT, while the petitioners have also alluded to the respondent's non-qualification without any fact known to law. Chief Wole Olanipekun, SAN, counsel to Tinubu, had pointed out in the final address dated July 14, both Atiku and Obi claimed INEC breached Section 134 of the Constitution when they announced Tinubu, who did not score up to 25% vote cast in the FCT in line with the law. Section 134, subsection 2B of the Constitution provides that a candidate for an election to the office of president shall be deemed to have duly elected where there being more than 2 candidates for the election. A, he has the highest number of votes cast at the election, and B, he has not less than 1/4 of the vote cast at the election, each of at least 2/3 of the states in the Federation and the Federal Capital Territory, Abuja. According to the INEC results, Tinubu was only able to garner 19% of votes in the FCT. He, however, argued that it was erroneous for the petitioners to call for the nullification of the entire election based on the FCT results. While we have premised this issue on the combined reading of sections 134 and 299 of the Constitution and 66 of the Electoral Act, in the course of our argument, it is apt to submit right from get-go that election is about votes and voters, and when votes and voters are mentioned in any part of the world, there is no superiority of votes or voters, as all voters and votes are equal. Adding that there is no superiority between the votes from voters secured in either Lagos or Kano, which are the most populous states, and Bayelsa, Ebonyi, and Ekiti, which are the least populous states. Olanipekun further argued that while Section 3, Subsection 1 of the Constitution specifically lists the 36 states by their respective names, the side note reads thus: States of the Federation and the Federal Capital Territory, Abuja, Section 299. For ease of reference and clarity, provides thus: the provision of this Constitution shall apply to the Federal Capital Territory, Abuja, as if it were one of the states of the Federation. The phrase "as if" has been defined in Corpus Juris Secundum, page 298, as connoting in the same manner and to the same extent. May we draw the attention of the court to the fact that there is no punctuation in the entire section 134, subsection 2B of the Constitution, particularly immediately after the states and the succeeding and connecting the FCT with the states. In essence, the reading of this subsection has been conjunctive and not disjunctive, as the Constitution clearly makes it so. Pressed further by this constitutional imperative, the Federal Capital Territory, Abuja, is taken as if it is the 37th state under by virtue of Section 299 of the Constitution. With much respect, any other interpretation different from this will lead to absurdity, chaos, anarchy, and alteration of the very intent of the legislature. Our courts have always adopted the purposeful approach to the interpretation of our Constitution, as exemplified in a host of other decisions, including but not limited to. State some cases for there, many cases for there. Also, the petitioners themselves admit this much in paragraph 107 of their petition, where they listed the SCT as the 37th state, after listing the states mentioned in section 3, subsection 1, as numbers 1 to 36. Again, the maxim res ipsa liquor applies to petitioners. Coincidentally, these sections of the Constitution were considered by the Supreme Court in the celebrated case of Buhari versus Obasanjo 2005. Blah blah blah. 1 to 105, and Apex Court held thus: this provision appears clear to me, where a candidate wins the highest number of votes cast and in at least 2/3 of the 36 states in the Federation and the FCT is deemed to be elected. I do appreciate any ambiguity in the provision, and even if there was one, This court is bound to adopt a construction which is just, reasonable, and sensible. Because they see Maxwell one thing, can't list some things. In my view, it will lead to absurdity and manifest injustice to nullify the election for the entire nation because of the nullification of the election of one state, some local government areas, wards, and units. Such a devastating result could hardly have been contemplated by the framers of the constitution. It is my conclusion, therefore, that the cancellation of the election in Ogun State and the other smaller components does not substantially affect the election of the first and second respondent. In the event this petition fails and same is dismissed with cost, which I assess at 5,000 naira in favor of each of the respondents. Shall be 5,000 naira again. The senior lawyer submitted that from the apex court's judgment above, it could have seen that even if results of election are cancelled in more than one state, including the FCT, that election is not rendered invalid, provided the winning candidate meets the constitutional requirement of 1/4 of the votes cast in 2/3 of the 37 states contemplated. Anything to the contrary would be devastating, and such was never contemplated by the framers of the constitution. All the winning candidate needs is a majority of the votes, and even if there was no election in one state, including the FCT, or even the election of a state or state including the FCT avoided, the entire election cannot be voided by or cancelled. In concluding our argument on the issue, we urge the court to hold that any election where the electorate exercise their plebiscite, there is neither a royal ballot nor royal voter, and that residents of the FCT do not have any special voting right over the residents of any other state or the federation, in a manner similar to the concept of preferential shareholding in company law. We urge this court to resolve this issue against the petitioners and in favor of the respondent, he pleaded. Faulting the entire petition, Olanipekun urged that, based on the argument and submissions contained in this address, the court should dismiss this petition as totally lacking in merit, substance, and bona fide. It has been glaringly shown and demonstrated by the presentation of the petition itself and the evidence presented by the petitioners, including the evidence of PW 27, that the petition itself is not only frivolous but also amounts to a crass abuse of the process of the court. Non-existent documents were being sourced and printed from the internet, among others, to be presented before this court after the filing of the petition, in furtherance of the abusive nature of the petition itself. According to him, it was glaringly evident that the election went very peacefully under a free and fair atmosphere, without proof in court of violence, ballot box snatching, and such other violence, ballot box snatching and such other electoral irregularities and vices. A state of affairs to which the petitioners' witnesses all testified. In fact, the election was concluded in substantial compliance with the principles of the Electoral Act, the INEC regulations, and manuals for the election. The unchallenged evidence on record, particularly the sole witness called by the respondent, is that the first petitioner has bidded unsuccessfully for the office of President of Nigeria severally, even till 2019, on the controversial issue of electronic transmission of results using the bimodal verification accreditation system, BVAS. Olanipekun said, coincidentally, a host of the witnesses called by the petitioners corroborated the unstable and or unpredictable nature of the technological devices or applications within the Nigerian terrain, as this will be demonstrated anon. The senior lawyer pointed out that it was wrong for the petitioners to build their case only on electronic transmission as the law also recognizes manual transmission. Our clear submission is that all the provision of the regulations created the alternative between electronic transmission and transfer, with the use of the article or, for instance, paragraph 38, subsection 1, which deals with movement from the polling units, states that on completion of all polling units voting and result procedures, the presiding officer shall, number 1, electronically transmit or transfer the results of the polling unit direct to the collation system as prescribed by the commission. Tinubu, while faulting the evidence of the 40 witnesses called by both Atiku and Obi, claimed their testimonies rather complemented the case of the respondent. The evidence of these witnesses essentially centers around the function of the beavers and IREV, and ultimately seek to impeach the veracity of INEC's explanation about the technological glitches that occurred on the day of the election and its implication on the overall result of the election. Without equivocation, it is a respectful submission that the petitioners have woefully failed in their adventure of theirs, and this will be seen through the direct analysis of their respective evidence. The evidence of PW2 is largely irrelevant for the benefit of the petition, as his witness statement on oath only attempted to outline the various features and functions of the beavers. The involvement of the Amazon Web Services (AWS) and its corporate profile, as well as the description of the IREV, its workings and configurations. However, despite the supposed authoritative assertions of this witness in respect of the beavers and the IREV under cross-examination, it's confessed that this is not familiar with the application on the beavers device, and that as a software engineer, he has never designed any software that was applied for the conduct of any general election. Though this witness had made several assertions in respect of the AWS in his witness statement, in all fairness to him, he opened up that he is not a staff of AWS. Similarly, the witness confessed that he was not aware of the number of software that makes the components that INEC used for the 2022 general election, as he is not an INEC staff, admitting that he never had any of the materials used for his supposed findings before the court, but on his laptop, which was not made available to the court. The irony about this witness is that despite his bogus claim and the bravado exhibited in the statement regarding the various technological issues, he virtually claimed not to be aware of anything at the end of everything. On the alleged US for future proceedings, Olanipekun urged that the witness of the petitioners failed to point to a single mention of the word fine in any of the documents forming part of the proceedings tendered as exhibit, which they admitted had not been registered in Nigeria in line with the clear provision of Section 3 of the Reciprocal Enforcement of Foreign Judgment Ordinance and Foreign Judgment Reciprocal Enforcement Act. About this news long. Without prejudice to the foregoing, it is our submission that there is no admissible evidence before this court that will make it void or set aside the election of the second respondent. May we submit straight away that the petitioners have not produced any evidence before this court to warrant voiding or setting aside the respondent's election, while the petitioners called 27 witnesses. It is our submission that substantially the cumulative effect of the terse evidence produced by them is against this petition. It's against the petitioners. We further draw the attention of the court to the fact that most of the witnesses came to rehash the evidence of others before them. In essence, the end result of their evidence is the alleged non-transmission of already collated and entered result on from EC8A to RF portal. We adopt our argument under issue 1 insofar that they relate to the evidence of witnesses and are appropriate for this issue. While we have already raised and argued preliminary objections to the petition itself, it is our further submission that every criminal allegation contained in the petition has not been proved, assuming without conceding that petitioners have not abandoned them, starting from PW1 Captain Joe Agbada through to 727. Each of them admitted that the correctness of the polling unit result. The law is trite that polling unit results constitute the foundation of an election. A successful challenge to the accuracy of a polling unit result is a condition precedent to the challenge of a transmission of such result, whether to the ward level, local government level, state or national level, whether manually or electronically. But we'll just stop and then at the gist with that. I might just take few reactions to this update. One JP Koto say nothing will happen. That's to the matter we to say nullifying the election based on the 5% will lead to chaos or anarchy. One JP Koto say, Baba, nothing will happen. Because the judges should do the right thing by disqualifying Bola Ahmed Tinubu. Other people say not only 25%, sir, you can also get nullified for the 460K forfeiture case and not having the majority of lawful vote cast. the easiest president to get nullified by the courts. And that person say, even if there is a rerun 100 times, Obi cannot win an election in Nigeria. You guys should stop deceiving yourselves. The North will not vote for Obi. First call reply like I say, rest bro, God's people. Now God's people they run am. I will just stop here. This is not too long. So now the update will fall out for the based on the tribunal lifestyle today and this news where this day come out. So I will make a clear now based on update man. Anyway, just thank God for everything.